Good evening, everybody. I'm very glad that you can join us wherever you are. This is a session this evening on voice identification and the law, and I'm delighted to welcome you. I'm delighted to chair some parts of this evening. You're going to be hearing from a number of highly distinguished academics and practitioners in relation to a really important project. It's a project relating to voice identification with a number of very different and very helpful strands to it that unite the interests of lawyers, of phoneticians, a variety of different people who are contributing in different ways, as you're going to hear. So you're in very safe hands. You're going to find that this is an interactive session. You're going to be invited to take part in a live interactions with a survey which is going to help the project that we're engaged in. And you're also going to hear some contributions from people who come from different perspectives, who are making their contributions in different ways. I'm delighted in due course to be welcoming Jeremy Robson, who's a colleague I've worked closely with at various times of my career before and after being a judge. I'm a criminal judge based in Cambridge. And you're also going to hear from Dr. Kirsty McDougall as well, the Assistant Professor of Phonetics at University of Cambridge, close to where I'm speaking from. I commend their contributions to you. I'm going to say nothing more at this stage. I'm simply going to pass over to Jeremy, who's going to introduce the first task that you're going to be invited to do. You're going to hear from him, and in due course, you're going to hear that there's going to be opportunities for you to interact in different ways. We'll have questions that we can moderate through the private chat as we go along, and we'll pick up any of your contributions and queries later on. You'll be able to talk to both Jeremy and to Kirsty as well. Jeremy, nice to see you, and you take over from here.
Thank you very much, Joe, and thank you for your sharing this evening. Kirsty's going to talk to you a bit later about the IVIC project, the Improving Voice Identifications project, which is a project between the University of Cambridge, the Oxford University, Nottingham Trent University and De Montfort University. And what this project aims to do is both understand a bit about how voice identification is working in courts at the moment, but also aim to try and improve some of the procedures which exist at the moment for investigators. But part of what we're doing is looking at how well people understand voice identification and some of the challenges of it. So what we'd like you to do to begin with is a short survey, and in a moment that's going to be posted in the comments section. Now, this survey is anonymous and it's entirely voluntary as well, but we'd be grateful if you could all take part. If you come from a legal background, it will probably take you 7 or 8 minutes to do. If you're non-lawyer, it'll take you slightly less time than that. But the data we collect from that is going to be used towards our project. We won't collect any data from personal data from you during this. We won't ask for your name, and the link's completely anonymous. So what's going to happen now is the link, I think, is going to be posted. Sandra's posted it. Thank you very much. So there's just going to be, you're given a few minutes to do that. We'll give you 15 minutes to do that with some music in the background whilst you do so. And then we'll resume at 7:20 with Kirsty talking about the role of a forensic phonetician. So thank you very much. Any questions about the survey, please pop them in the chat. But if you just want to do that via the Qualtrics survey tool, that would be much appreciated.
Well, welcome back. Hope you enjoyed the music. Hope you enjoyed doing the survey as well. I've just done it, and I can see that that 27 people have done as well. And you'll see some of the interesting ideas that you've been asked to think about in that survey. And over the course of the next period, as part of this session, you're going to hear a little bit about why we have those elements in the survey and what issues they address. I was just struggling for a little bit to be able to work out where as a legal professional I fit in as a practicing circuit judge, but I think I found the box. So there we are. That's my contribution too. Well, I'm going to introduce you now to Dr. Kirsty McDougall. She is the Assistant Professor of Phonetics at the University of Cambridge, and she's a Fellow of Selwyn College. She works with phonetics, and she does that both in a legal context, in a court context, thinking about how phonetics interacts with the world of the courtroom. And she's thought very hard and has worked on the selection of foils, for example, for voice parades. That's working out what the array of different voices ought to be when coming to a voice parade. So without further ado, I'm going to refer now to Kirsty. Kirsty's here. She joins us, and I look forward to hearing from you. Thank you, Kirsty.
Thanks very much, Joe. And thank you everyone for joining us for the webinar this evening. So this section of the evening is about the role of the forensic phonetician in cases involving voice evidence. But before I get into this topic, I'd like you all firstly to listen to this voice.
But I didn't mention you at all. They kept on pushing for your name, and I said no almost every time. I almost slipped up when I was talking about driving home in the car, and apparently they've got a photo of both of us in the car. And I also they were asking about the DIY shop, and asking if I knew a Robert Freeman who worked there, and I said if I did know a Robert Freeman, he doesn't work there, and that kind of got their back up.
Okay, you've just witnessed the voice of a man committing a crime. At the conclusion of this presentation, we'll have a little voice parade to see if you can recognise the voice of the perpetrator. So in my talk this evening, I'm going to firstly talk very briefly about my background as a phonetician, what it is phoneticians do, what is this discipline phonetics, and in particular, what is forensic phonetics. I'll then talk through the three main areas concerning speaker identity that a forensic phonetician gets involved with. So these are the tasks of speaker profiling, forensic speaker comparison, and ear witness identification, which leads to voice parade construction, which is the main focus of the IVIC project. So my background then, I studied linguistics and mathematics as an undergraduate in Melbourne, and I specialised in phonetics within my MPhil and PhD in linguistics in Cambridge. So for both the MPhil and PhD, I did research in forensic phonetics, and I've continued in this forensic area from that time onwards. So I've been doing research and teaching in phonetics and forensic phonetics since 2005, mainly at the University of Cambridge. I started helping out as an expert witness in 2004. I did my first case under the guidance of my then PhD supervisor, Professor Francis Nolan, who's incidentally also a member of the IVIC research team. And I've done occasional casework on and off since then. I particularly specialise in voice parades when it comes to forensic casework, whereas my research is in all the different areas of forensic phonetics. So what is phonetics then? Phonetics is the branch of linguistics in which we seek to understand how humans produce and perceive speech sounds. Phoneticians are particularly interested in trying to describe the speech sounds of the languages of the world, and we have a range of techniques to do this: articulatory, auditory, acoustic, and instrumental. In articulatory phonetics, we focus on the human anatomy and what it is that we can do with our vocal tract. So we describe the speech sounds of the languages of the world in terms of the way they're articulated in the vocal tract. And this is done in conjunction with auditory phonetics, looking at the listening side of the sounds. So we analyse speech sounds through listening techniques. This is coming from the sort of traditional approach that you might be familiar with in the story of Professor Henry Higgins in the musical My Fair Lady, where he claimed to be able to identify where a speaker came from, right down to the street where they lived. In auditory phonetics, speech sounds are described using the International Phonetic Alphabet, which you can see on the screen there. Another source of information comes from the acoustic analysis of speech. So in acoustic phonetics, we analyse the physical properties of speech sounds using representations like waveforms and spectrograms. You can see on this slide waveform and spectrogram of a female speaker, you can guess which one, saying the words forensic phonetics. Then phoneticians in modern times have all sorts of other instrumental techniques they also use for learning more about how speech works and how humans communicate, things like magnetic resonance imaging, ultrasound, and electromagnetic mid-sagittal articulometry. There are examples and pictures of all of these techniques on the screen there today, although they're not quite so directly relevant for forensic casework. So what is forensic phonetics more specifically then? In forensic phonetics, we're looking at the application of phonetic analysis to criminal cases where speech is involved, and also in some cases, civil cases. There are two main kind of situations. Cases involving recorded speech, where you've got some incriminating speech that's been recorded, typically over the telephone, also sometimes from a police bugging device. And then there's the other situation where there's no speech recording of that incriminating speech, but a victim or a witness from the crime scene remembers a voice that they heard. So if we look at those two situations in terms of contexts for looking at questioned speaker identity and the involvement of the forensic phonetician, the tasks that come up are shown by the arrows on the screen there. So first of all, where we have got a recording of the incriminating speech, there's speaker profiling by a phonetic expert, and then there's forensic speaker comparison by a phonetic expert. I'll talk more about each of those two tasks on the next few slides. The third one there, voice comparison by lay listeners, such as police officers or jurors, I'll leave for Jeremy to talk about because the phonetic expert is not involved in these cases. And then, of course, the remaining situation where there's no recording of the incriminating speech event, but the witness heard this speech. This is a case for ear witness identification, which is usually collected by a voice parade, and that's the main focus of the IVIC project and quite a bit of what we're talking about today in the webinar. Okay, so the first of those recorded speech situations was the speaker profiling by a phonetic expert. This is what happens when the police have got a recording of a speaker committing a crime and they want to know who the speaker was. So it might be a recording of a ransom demand, a hoax 999 call, threatening phone call, blackmail, stalking, and so on. It's a very early stage of the investigation. The police don't yet have any suspects, and the phonetician is asked to do an analysis of the voice on the recording to try and reduce the field of suspects. So the phonetician will make an assessment of demographic characteristics such as the sex, likely age range, regional and social background of the speaker, perhaps their educational background, and note any unusual or interesting individual features such as an unusual pronunciation, perhaps a foreign accent, or a speech pathology such as a stutter. The phonetician will draw up a profile of the speaker to assist the police with their investigation. Very famous example of speaker profiling that you might be aware of is the Yorkshire Ripper hoax case. This involved the murder of 13 women in Yorkshire between 1975 and 1980. While these tragic murders were unfolding, the police received several letters and a tape recording from somebody purporting to be the Yorkshire Ripper. And so with the tape recording, this is where speaker profiling came in. I've got the beginning of the recording for us to listen to now.
I'm Jack. I see you are still having no look catching me. I have the greatest respect for you, George. But Lord, you are no nearer catching me now than 4 years ago when I started. I reckon your boys are letting you down, George. You can't be much good, can you?
Okay, so the police obviously wanted to know who the speaker on the recording was, and a phonetician called Stanley Ellis was called on. He did a speaker profile. He determined that the accent was a Sunderland accent and probably from the Castletown area. Unfortunately, the recording was a hoax, so it was a false lead in the investigation. The murderer was in fact a man with a Bradford accent called Peter Sutcliffe. The hoaxer was identified about 26 years later through DNA evidence for a completely different case and was a man called John Humble, or Wearside Jack. He was indeed from Sunderland, from the Ford Estate area, which is about 1 mile from Castletown. So the speaker profile was very accurate, although unfortunately it didn't help with tracking down the Yorkshire Ripper and was a bit of a distraction. Although it has to be pointed out that the phonetician also suspected the tape was a hoax, and he did try and convince the police of this at the time. So this brings me now to the second area of a forensic phonetician's casework, and that is the task of forensic speaker comparison. So this is quite similar to speaker profiling in that there's a recording of a crime taking place and the police would like to know who the speaker on the recording is, but the investigation has progressed further and they've identified a suspect through other sources of evidence. So the suspect has been interviewed in the police interview, which is recorded. So there's a recording of the suspect's voice from that interview, which they then ask the phonetician to compare with the disputed or incriminating sample, the sample from the crime. So this comparison exercise is called forensic speaker comparison, and the phonetician will try and assess the likelihood that the speakers on the two recordings, what's the likelihood of them being the same person. For forensic speaker comparison, the phonetician draws on quite a range of techniques. I sort of introduced some of the phonetic approaches in the introduction to my talk, and that's where these come in. So the phonetician will use auditory analysis, drawing on listening techniques to analyse the pronunciation of vowels, consonants in the recording, as well as looking at the intonation, rhythm, voice quality, and so on. And this will be done in combination with acoustic analysis, making measurements of all sorts of features of those various sounds that they've done the auditory analysis of. So with the acoustic analysis, you'll be looking at spectrograms and waveforms and measuring durations, pitch measurements, resonances of the various vowel sounds, and so on. In modern times, computational approaches from automatic speaker recognition are increasingly being researched and starting to play a role in forensic speaker comparison cases as well. In forensic speaker comparison, there are quite a number of problems in trying to do these analyses. The recordings are typically very short, or often very short. For example, you might have just 10 or 15 seconds of a hoax call to 999, not very much material to analyse. Similarly, the police interviews sometimes don't provide very much material. If it's an uncooperative suspect doing a no comment interview, then there's insufficient material to do a proper analysis with. The recordings in these cases are often in very poor quality with lots of background noise, and if a recording was made over the telephone, then you'll have a reduced range of frequencies available for analysis in that recording. The two recordings to be compared, the incriminating sample and the known suspect sample, are not equivalent in lots of different ways. The content of the utterances you can't control. You'll have different words and different phrases being spoken on the two recordings. And the two recordings will be typically produced with different speaking styles. So the police interview recording might be quite a reluctant, soft speaking style, perhaps in comparison with a more stressed and urgent speaking style on the incriminating sample. It's also possible that disguise might be involved, although actually disguise occurs much less often than you might predict in these kinds of cases. Underlying those various practical problems for forensic speaker comparison is a more theoretical fundamental problem, and that's that voices are not like fingerprints or DNA, whereas with fingerprint you're taking a direct representation of part of an individual's anatomy. A voice or a speech recording is an indirect representation of events, dynamic moving events that are connected to a speaker, but not a direct imprint of their body the way a fingerprint is. There is no technique for identifying voices with 100% certainty. The science has not reached this stage. And this is because voices vary within individual speakers. We call this within speaker variation. We don't say the same word in exactly the same way on any two occasions. We change the way we speak depending on who we're talking to, what mood we're in, the time of day, how formal the context is, whether we've got a cold, and all these different things contribute to variation in individual speakers' speech performance. Furthermore, there are public misperceptions about what voice identification evidence can achieve. I'm sure you're all familiar with the CSI effect, this problem of television and films and television shows giving the wrong impression about just what is possible with these various scientific biometric techniques. Forensic speaker comparison evidence is probabilistic and not absolute, and for this reason it should be used in conjunction with other forms of evidence and not just used on its own to bring a case to prosecution. Okay, so this brings me to the third of those three main areas for the forensic phonetician's work, which is ear witness identification, the situation where there's no recording of the voice, but a witness has heard a voice at a crime scene. So the ear witness or lay listener has heard the voice of the perpetrator and not seen them, not had a good look at not got a good look at the face at the time of the crime. Perhaps the perpetrator was masked or the victim was blindfolded. The witness believes that they would recognise the voice of that perpetrator if they heard it again. So the police can conduct a voice parade to see if the witness is able to pick out the suspect's voice from a lineup of voice samples. There are two different situations within this ear witness scenario, and that's either an unfamiliar voice that the witness has heard or a familiar one. So if it's an unfamiliar voice that they hear at the crime scene, the question that they're asked when doing a voice parade should be about attempting to recognise the voice of the perpetrator, if indeed that voice is present among the lineup. Whereas if it was a familiar voice that they heard at the crime scene, they've made the identification at the time of hearing that voice. They believe it belongs to Mr. Smith, somebody already known to them. And in this situation, a voice parade should be testing the witness's ability to recognise the voice of Mr. Smith, the voice of the suspect. They've already made the identification, if you like, at the time of hearing that voice at the crime scene. So in England and Wales, we have an existing procedure for carrying out voice parades. This was published in a Home Office circular in 2003. And it was developed by DCI John McFarlane and Professor Francis Nolan, I've already mentioned, that's my former PhD supervisor. They put it together in conjunction with an arson case in 2001. And they developed the procedure based on the work of the Dutch phoneticians Breuders and Rietveld and various others. And it was also done as a sort of analogy with the visual identification procedure. The procedure that's described in that Home Office circular is still what we use today, although there have been some minor modifications due to advances in technology. So how does this procedure work then? We start with the suspect's voice. Because all suspect interviews, police interviews in the UK are recorded, this is a useful and essential part of how our voice parade method works. The phonetician analyses the recording of the police interview of the suspect's voice to assess how suitable that voice is for a voice parade. If the suspect's voice is very unusual sounding, perhaps has an unusual speech habit or speech pathology, some kind of unusual accent, then the phonetician would recommend that no parade went ahead because it's not possible to get, it's not going to be possible to get enough foil voices for a fair comparison against the suspect's voice. The phonetician also has to make sure that there's enough material in that suspect recording to provide sufficient source material to form the sample for the voice parade, and that material is a suitable recording quality. There are several advantages of using this police interview material for constructing the sample of the suspect's voice. The suspect was aware that they were being recorded during their interview and alerted to its potential use as evidence at the start of the interview with the caution, although admittedly not directly, that it could be voice evidence as well as other kinds of evidence that their interview is used for. In the interview situation, they're unlikely to disguise their voice, and the fact that we're using interview material gives us a natural, spontaneous speech style, which is better for the witness recognition task. To prepare the suspect's sample for the parade, we do a digital editing process, pasting together a collection of utterances to form a collage of speech that's characteristic of the speaker. So little phrases like, yeah, I don't know, about 3:30, round the corner, second on the left, and so on. Avoiding longer utterances or any sense of narrative from the interview. The utterances are put in a relatively random order. And also, of course, omitting any mentions of crime-related information in the interview recording. The duration of the voice sample that's put together in this collage is 60 seconds. This brings me now to what we do for the foil sample in the voice parade, and it's much the same procedure using other police interview recordings of other speakers not connected to the main crime in question. So this is really important because it gives us a uniform speech style. If you were to take interview material from the suspect and then get a bunch of people to read those same words, then the suspect sample would stick out because the spontaneous speech sounds very different from read speech, and that's just not fair to the suspect at all. It's very important to have uniformity in your speech styles across the samples. 8 foil voices are required need to be found to form a parade of 9 voices altogether, with the suspect voice. And the Home Office guidelines stipulate that the identification officer should provide at least 20 recordings from unrelated cases, which are interviews of interviewees of similar age and ethnic, regional and social background to the suspect. So the phonetician will select from those 20 recordings the most appropriate voices to be the foils, and then run some experimental checks to make sure that the parade really is fair. These experimental checks are firstly a perceptual distance test. This is an experiment to check that all the speakers in the parade are roughly equally different from each other in terms of how they sound. And to do this, we get a group of naive listeners to judge the similarity of all pairings of the 9 speakers in the parade and run some statistics to make sure that the suspect isn't sticking out from the main group. Then the second experimental check is a mock witness test. This involves getting a different group of naive listeners to undertake test runs of the voice parade to make sure that, again, that the suspect doesn't stick out for some reason to do with stereotyping or bias. The parade is then presented using PowerPoint slides. Several random orderings of the 9 voices are prepared for the identification officer by the phonetician. And how it works is the PowerPoint slide will have a letter for each voice on the slide, and then the voice sample will be playing as you see that letter. So it looks like this. You'd have the first voice sample for 60 seconds, then the second voice sample, and so on. Then once the 9 voices have been played, there's a final slide with 9 buttons, and the witness is able to request to listen to any of the voices again as many times as they like before they make their final decision. Okay, so you'll recall that you heard a perpetrator at the start of this session. For a bit of fun, we're going to do a mini voice parade now. This is not a proper one with 60 seconds for each speaker, because that would take far too long. This is just a small little fun thing that I prepared for actually a radio program. So you'll just hear one phrase from each of 6 voices and see if you can remember who you heard at the start of the presentation. If we're in a lecture theatre, I would have got you all to put up your hands for each of the voices at the end to see how much agreement there was, but we can't really do that in this online sort of webinar, so we'll just have to see. Okay, here's the parade.
Voice 1.
I don't know Robert Freeman. No, it doesn't ring a bell at all.
Voice 2.
No, that name doesn't ring a bell. I don't think I've ever met anyone of that name.
Voice 3.
No, I don't know anyone by that name.
Voice 4.
No, I don't know Robert Freeman. I don't know Robert Freeman, and I wasn't there.
Voice 5.
As we've already said, I don't know any Robert Freeman.
Voice 6.
I don't know anyone by the name of Robert Freeman.
Okay, so feel free to put your thoughts about these 6 voices in the comments. Yes, as I said, if it was a lecture, I would be asking you voice by voice for a show of hands, but we can't really do that now. So I'm just going to give you a few moments to put something in the chat if you'd like to, and then I'll reveal the answer. Okay, here's the answer.
Voice 4.
No, I don't know Robert Freeman. I don't know Robert Freeman, and I wasn't there.
And a bit of the original perpetrator.
But I didn't mention you at all. They kept on pushing for your name, and I said no almost every term.
It's certainly worth emphasising that this was just for a bit of fun, and the situation of hearing the perpetrator as you did at the start, which was only for a very short amount of time, would not lead to a voice parade exercise. In a real case, it would need to be a much longer exposure to the voice that the witness received before we would consider actually doing a voice parade. But having said that, when I do this exercise in a lecture theatre, usually more than 3/4 of the group will choose voice 4. So there's definitely something in it if it's not everyone that recognises the voice later on. So this is my final slide for this section then. I've explained today that phonetic expertise plays a role in cases of questioned speaker identity, both those cases where there is a recording of incriminating speech. These are the cases for, these cases include speaker profiling and forensic speaker comparison exercises for the forensic phonetician. And as well, when there's no speech recording, but a crime involving speech has been heard by a witness, and this will lead to ear witness evidence being collected by a voice parade. I outlined the procedure used for voice parade construction in England and Wales with the Home Office guidelines. And then I'd like to emphasise really that voice identification evidence is very much a growing area with increasing research developments and a lot of innovation. And just the fact that we have more opportunities for recording voices and with mobile phones and the various devices we all have now, this is very much a growth area. In my later little section in the webinar, I'll be giving an introduction to the IVIC project, but the next presentation that Jeremy will provide will be looking at the legal perspective of these various types of voice identification evidence. Thank you.
Thanks, Kirsty. That's absolutely fascinating. It's like lifting the bonnet and looking into the engine room of the, or the engine for the phonetician, looking at the tools that you've got there, the mechanics of voice formation, the characteristics of questioned voices, and the mechanisms for what is effectively a scientific experiment, and to see if you can make effective and powerful voice comparisons. That's fascinating. The next question is how that's going to relate to the critical task of translating those experiments into persuasive evidence in court. Voice identification may be comparatively rare. It is rare in criminal cases in this country, but it's sometimes absolutely critical. And you're now going to hear from Jeremy Robson talking about the legal aspects of voice identification. Jeremy is a senior lecturer in law at de Montfort University, and we first met each other when he was at Nottingham Trent University. And he, as a criminal barrister, has got the experience of being in court and trying to argue voice identification or identification processes one way or another. And he is a critical part of this team. So can I hand over to Jeremy?
Thank you very much, Joe, and it's great to have you. And you played a key part in ensuring that the standards of voice identification evidence in court are maintained, and I'll talk a bit about that in a few moments. But as Joe said, my background before I entered academia was as a criminal barrister in the East Midlands. And I only encountered a couple of cases involving voice identification. But because of that, the law isn't as well developed in respect of voice identification as it is in relation to eyewitness identification. So those of you who are lawyers will know that we've got a very robust set of procedures when dealing with eyewitness evidence. But the Court of Appeal has really had to wrestle with voice identification on a case-by-case basis. And what I'm going to try and do this evening is really just draw together some threads from that and talk about the overall approach. And if you are a practitioner, hopefully give you some things to think about for if you have to deal with a case involving voice identification. And my My slide has gone. Excuse me a moment. Right, sorry about that. So I'm going to be looking at voice comparison by experts, ear witness identification, voice parades, and voice matching exercises. So as Kirsty said, there are really two main schools of thought in relation to expert analysis. Auditory analysis, which involves the phonetician listening to the two voices and using their knowledge of phonetics in order to identify similarities and dissimilarities. And acoustic analysis, where a spectrogram is produced, and that measures physical qualities of the voice, resonance, and the expert will look at the two spectrograms and look for similarities there. And there's a considerable school of thought that acoustic analysis is the superior form of expert analysis, that it produces qualitative data of higher standard, which is more objective. But that doesn't mean auditory analysis is inadmissible. And the Court of Appeal considered this question in a case called Rob in 1991. If you're a lawyer, you're probably familiar with the case of Rob. It's quite an important case on expert evidence. But in that case, which was a kidnapping, where there were recordings of the ransom call, the prosecution presented auditory analysis only, and they called an expert who had listened to the tape and made the measurements. And on appeal, under cross-examination in court, he accepted that he was pretty much a loner in that respect, and that most other experts in the area considered acoustic analysis to be preferable, and that in many other European countries, auditory analysis on its own would not have been accepted. So the case went to the Court of Appeal, and the Court of Appeal dismissed the appeal. They said there was no rule that prevented auditory analysis on its own being admissible, that the jury had heard what the expert had said, that he'd accepted there were weaknesses to it, and they could make their own assessment of the evidence. Now, that approach seemed to change in 2003 due to a case in Northern Ireland called O'Doherty. And O'Doherty was charged with aggravated burglary, and there was evidence of recordings of threats made to the premises which were attacked. And Mr. O'Doherty was convicted on the basis of an auditory analysis of the tapes and his voice. However, when the case came to trial, when he was convicted and when it went to appeal, Francis Nolan gave evidence on his behalf, outlining some of the problems with auditory analysis on its own, and explaining why acoustic analysis was to be preferred. And the Court of Appeal for Northern Ireland accepted that, and they said that in future they would not allow prosecution to proceed where the only evidence was auditory analysis. So that seemed to be the end of the line for auditory analysis on its own. However, the Court of Appeal in England and Wales declined to follow that approach, and in a case called Flynn, which we'll look at in a bit more detail in a few moments, the Court of Appeal said there was no rule in English law to that effect, and if the prosecution wanted just to use auditory analysis, or the defence just wanted to use auditory analysis, that was really a matter for them and a matter for the jury to assess in assessing how much weight to attach to the evidence. Now, since then, as Kirsty's mentioned, there has been development of technology, automatic speaker recognition technology, which does a lot of the work that experts do. And it's perhaps inevitable that that's going to play a part in criminal cases in the future. However, the Court of Appeal so far has been reluctant to admit that evidence. And in a case called Slade in 2015, an attempt to introduce a technology called BatVox was rejected by the Court of Appeal. Now, it's probably useful to look at that case in context. So what happened in Slade was a group of defendants were convicted of an armed robbery, and there were recordings made from inside the car, which was used in the robberies, and amongst a variety of other evidence. On having been convicted, the defendants appealed to the Court of Appeal, and they wanted to use the BatVox evidence as new evidence. In other words, the results of the BatVox analysis suggested that it wasn't them who was on the recordings. Now, because this was a defence application to introduce evidence out on appeal, that's a high threshold that has to be met, and the courts have to be satisfied that the evidence is of a high degree of cogency. And the Court of Appeal were concerned about the way the technology worked. And the way BatVox worked was that the suspect voice would be run through the system, as would the defendant's voice. But they would then be both compared against each other, but against a database of other voices. And the analysis that the BatVox produces would be effectively whether the suspect voice was closer to the defendant's voice or closer to the general population. And it produced a likelihood ratio. And the Court of Appeal weren't satisfied that a satisfactory basis for that likelihood ratio had been established, and that there was enough voices on the database to justify the conclusions that BatVox were producing. But they were very careful not to rule definitively on it, and they very much anticipated that in the future technology would come along which would do this and would be more robust, and there's been work going on in this area since then. So I think it's only a matter of time before speaker recognition software which does produce a match and link a defendant to a suspect voice is admitted in court, and the Court of Appeal uphold that. I'm very disappointed there's not an article being written on Slade called "Come On, Feel the Noise," but hopefully any matter of time. So what about lay witness identification? Well, this is a situation really where someone who's unqualified hears a voice and thinks, I know that voice, it belongs to that person. Or alternatively, they hear a voice at the scene of a crime and subsequently hear that voice again and recognize it. This is perhaps the most problematic area of evidence, because ultimately the case may turn on the accuracy of that witness's identification. In eyewitness cases, criminal practitioners will be very familiar with the case of gives the guidance that that needs to be given in cases involving eyewitness identification, and judges have to give a very clear direction at the end. Now, in a case called Hersey in 1998, the Court of Appeal accepted that voice identification could be the basis of a conviction and reminded judges that they needed to give a modified version of the Turnbull direction. However, unfortunately, they didn't give much guidance as to what that modification should consist of. However, in 2008, in the case of Flynn, the Court of Appeal gave much more guidance on some of the problems with voice identification. Now, Flynn concerned a case where, in fact, it was police officers who were listening to covert recordings made in a van. But the Court of Appeal went on to consider some of the factors that were important in considering voice identification. Firstly, the quality of the recording of the disputed voices. Well, that doesn't usually occur with lay witnesses. The gap in time between the listener hearing the known voice and his attempt to recognize the disputed voice. The ability of the individual lay listener to identify voices in general, and research shows that the ability of an individual to identify voices varies from person to person. The nature and duration of the speech which is sought to be identified, and the Court of Appeal noted that some voices were more distinctive than others, and the longer the sample of the speech, the better the prospect of identification. And perhaps most importantly, the greater the familiarity of the listener with the known voice, the better his or her chance of accurately identifying a disputed voice. However, the Court of Appeal reminded practitioners that a confident recognition by lay listener may nevertheless be wrong. And it went on to say that the key to admissibility with ear witnesses was whether the witness possessed some special knowledge of the suspect that enabled him or her to recognise the suspect's voice. And the most common example of such evidence is the knowledge of a close friend or relative. So if you are a lawyer and you're dealing with a case which turns on ear witness identification, it's really important to establish the basis upon which the ear witness claims to know the speaker, because that's going to be central to the accuracy of their identification. There's now some very clear guidance in the Crown Court Compendium written by Joe at paragraph 15.7, and that gives judges some very clear guidance as to what should be said in such a case. But there are a few things that's worth taking into account if you're dealing with a case like that. The first is that you might have a description of the voice which has been taken by the officer early on in the proceedings, when they've first spoken to the witness. And that might appear to superficially match the suspect. But that's probably because, as humans, we have a limited vocabulary for describing voices. And we can't describe voices in the same level of detail that we can describe physical appearance. So you might have a description which is male, Manchester accent, quite deep. And if your suspect has a voice that sounds like that, superficially it looks the same. However, if that was an eyewitness, we'd expect much more by way of detail. We'd expect things such as height and build and eye colour, maybe hair colour, haircut. And we would use that as a way of establishing inconsistencies. So the fact that a description looks superficially similar isn't particularly helpful, because there's less chance of the witness being inconsistent. The next point is worth remembering is that the relevant time for assessing the observation is the length of speech and not the length of time the witness is in physical proximity to the witness. And that's important because in a situation where a witness has been party or witnessed a crime where they've not been able to see the appearance of the assailant, they may have actually only had very limited chances to hear them speak. I've certainly seen a summing up where the witness observed their attacker for about 10 minutes, but said, well, I didn't know who it was. I couldn't tell who it was because they were wearing a mask. But then they spoke and I recognized them. But the assailant had only spoken 6 words. And that was summed up to the jury on the basis that the observation had lasted 10 minutes. And so it was a lengthy observation. In reality, those 6 words would have probably taken 2 or 3 seconds to speak. So would very much be at the fleeting glimpse end of what we consider acceptable in terms of an eyewitness identification. So drilling down into what was said and how long it lasted for is going to be important. And the third thing to mention is, as we'll come on to talk about in a second, it's less likely the witness will have had their identification tested on an ID parade. So what about voice parades? Well, Kirsty's just very helpfully demonstrated what a voice parade consists of, and that there is best practice now in Home Office guidelines. However, as she's probably indicated from the level of detail that's needed and the input that's required, they are quite difficult to administer. And I looked into this in 2017 and discovered that whilst there were some forces that used them where they could, there were a number of police forces across the country that had made policy decisions that they were never going to use them. And so a key investigative tool is being lost. The Court of Appeal allow their use. In Hersey, again, they acknowledged that they were useful both for the prosecution and defence, but they're not being used consistently. So is there an obligation? Should police forces be doing this more frequently? Because the position with eyewitness identification is that where a witness disputes an identification, police officers have to conduct a physical lineup unless there's a good reason not to. So does that principle extend to ear witness evidence? Well, that argument was first made in a case called Gummerson in 1999. And the Court of Appeal rejected that argument. However, since then, what the Court of Appeal said in Gummerson was, well, you know, there's nothing in the codes of practice that talks about voice identification, so it's not covered by the codes of practice. But there have been two changes since then. Firstly, there's a House law decision in Forbes, and that was a case on eyewitness identification. But that was the case where Lord Bingham said that in every case where identification is disputed, there should be an ID parade, and that there was an obligation to follow Code D of the Police and Criminal Evidence Act, which is the code of practice which determines how identification parade is conducted. And then in about 2012, there was an amendment to Code D of PACE, which made reference to voice identification. And it said that whilst the code concentrated on visual identification procedures, it does not preclude the police making use of oral identifications, such as voice identification parades, where they judge that to be appropriate. So Code D was now starting to recognise voice identification. And I argued in the Criminal Law Review in 2017 that whilst it wouldn't be possible to do a voice identification in every case, there was an obligation on the police to consider it and to see if it was feasible if a voice identification was disputed. Someone took that argument to the Court of Appeal earlier this year in a case called Crow, and the Court of Appeal said no, Code D is not intended to cover voice identification. It only deals with visual identification procedures. There's an Irish case, which confusingly is also called Crow, however, which takes a different view. The Court of Criminal Appeal quashed a conviction where a defendant had been put at the scene of a crime through a voice procedure that wasn't compliant with the standards for voice identification parades. And considering a lot of the English authorities, they said, no, voice parades should be conducted. They are a valuable tool that protect the rights of the suspect. So it's certainly something to think about in a case where a suspect might be able to be picked out on an ID parade. There are two other types of situation matchings might occur. The first is what are sometimes called ad hoc voice matchings conducted by the police. And this deals with a situation where the police have a covert recording and they get officers who are involved in the case to listen to that and say who the people on the tape, who on the recording are. And this is what had happened in Flynn. The recordings were made, and then the officers who'd arrested Flynn and his co-defendant who'd interviewed them were then asked to listen to the tapes and say whether the people they'd arrested were the people on the tapes. And perhaps unsurprisingly, the officers concluded that they were. But when it was looked at properly, it fell apart for a number of reasons. Firstly, there was no record of when those recordings had been listened to, in what circumstances, and how frequently. And equally, the recordings were of such poor quality that when expert phoneticians listened to them with quite sophisticated equipment and repeatedly listened to them, they said the samples were so poor that no one could do a match from them. And so Flynn's conviction was quashed. And the Court of Appeal laid down some guidelines that should be followed in cases involving police officers. There has to be a proper recording of the process, who's listened to what, when. If an officer has made a compilation of a transcript beforehand, they should make a note of that. And if the officer who's prepared that transcript has answered it who they think is speaking, that must be recorded. All officers attempting the identification must have an unannotated transcript, because one of the problems in Flynn was there was this cumulative document going around where everyone was adding their own identifications to it. So each officer attempting it must have an unannotated transcript. And the identification should be conducted by an officer who's not been involved in the investigation. And if those safeguards aren't complied with, that evidence should be excluded. But realistically, I think if there is recording available, I think there needs to be a really strong reason why you're using this method of matching the voice rather than getting one of the expert phoneticians in who can give a much better and richer analysis of the evidence. The final category of voice matching is something that shouldn't happen very often, indeed shouldn't happen at all, but is still permitted but does bring a high level of risk to it. And that's where jurors are invited to engage in voice matching. So in other words, a tape is played during the trial, there is expert evidence produced, but the jury are basically told to consider whether they think the voice that they've heard is the same as the defendant who they've heard give evidence. And this is something that is currently permitted, albeit it doesn't happen very often. The first case to consider this in detail was a case called Sullivan in 2012, which was an appeal from His Honour Judge Hammond in Leicester Crown Court. And what happened here was there was an expert who had done the matching exercise, but the tapes were played to the jury whilst he gave evidence to show how he'd done that. And the Court of Appeal said, well, that's perfectly fine. It's okay for the jury to hear those recordings to help them understand the expert evidence. But that got broadened in 2015 in a case called Capicania, which was a mortgage fraud. Now, what happened there was a number of defendants had telephoned banks and building societies making false applications for mortgages. And the prosecution had got recordings of those, but they never got their own expert analysis of it. Mr. Capicania and his co-defendant each denied that they were involved and each blamed each other. And when Mr. Capicania gave evidence, his co-defendant cross-examined him and put the tapes in evidence and said, this is you speaking, isn't it? And at the conclusion of the trial, the judge, although he warned the jury to be careful, invited them to consider whether the voice on the tape was Mr. Capicania or his co-defendant. And the Court of Appeal said, well, that's perfectly acceptable, that because it wasn't prosecution evidence, the judge had limited powers to exclude it, and so it was properly before the jury. However, as I'm going to go on to talk about in a second, there are a number of risks inherent with this type of identification, so much so that, in fact, the quality of the evidence obtained in this way is likely to be so poor that it probably fails the basic test of relevance. However, in Archbold, which is the main text that criminal judges and barristers use in the criminal courts, they say that this procedure is still acceptable. Archbold quotes a case called Corgbara, although actually reading the cases would seem to suggest that what they're actually referring to is a quote in Corgbara from a case called Bulicek, which says that the key factors are the quality and quantity of the material being compared. The greater the amount of material, the greater the similarity in the circumstances in which the voices were spoken or recorded, and the greater the number of similar words used, the more useful the comparison. So I looked at this a couple of years ago with Harriet Smith, who's a psychologist at NTU, who's part of the IVIC team, and we looked at some of the factors that made this unreliable. And we considered, well, what would the standards be if you were doing this as a scientific experiment? Because one of the things you need to be alert to is the risk of creating false positives, false identifications based on other factors. And there are a number of factors that we identified as making this approach dangerous. The first is that juries will perceive sounds differently. If you have 12 people on a jury, they're all going to hear things in a slightly different way. And that especially, as you get older, as you get over the age of 45, the range of frequencies that you can hear starts to diminish, and that affects how you hear words. The S sound, for example, changes. So everyone's going to be hearing the sound in a slightly different way. The quality of the recording may be very poor, or indeed the speakers over which it's being played. And obviously it's going to make a difference as to whether you are hearing this over speakers or via headphones. Variability in voice is going to play a factor. Witnesses in court are told to speak loudly and to speak clearly and to speak slowly so that everyone can take a note. And that may be very different from the way their voice is presented on the recording. The order in which it is played is significant. So we did some experimental work at Nottingham with a poor quality recording followed by a better quality recording. And the way in which they're played makes a difference. If you have the better quality recording first, followed by the poor quality recording, much higher levels of accuracy than if it's the other way round. And the risk of false positives goes up considerably when the poor quality recording is played first. However, in a trial, if the recording is played as part of the prosecution case and then the defendant gives evidence afterwards, then you've got it that way round with the weaker sample being heard first. So that increases the risk of false positives. There's going to be an inherent bias. We know that bias is an important factor in eyewitness identification, even more so in ear witness identification. And juries will know that the defendant's been arrested. They may know there's other evidence, and that's to impact upon their assessment of the evidence. And the acoustics of the courtroom will vary from courtroom to courtroom. I did discover during the course of the research that there was a period where there were building regulations for courts that attempted to standardize the acoustics of the courtroom. But in practice, that didn't get very far. And every courtroom will have its own acoustics. Again, some of you who are practitioners might be familiar with some of the big old courtrooms like Lincoln Crown Court. That's going to have a very different acoustic landscape to another courtroom. So the tape will sound different in different rooms. So fundamentally, this is really a very dangerous strategy in terms of generating false positives in the mind of the jury. Juries thinking that the voice is the same when it might not be. And again, fundamentally, if there is a recording of the voice that's there to be played, then there should be consideration given to getting an expert to do the matching exercise rather than it be on an ad hoc basis. So thank you very much, everyone, for your time this evening. In a moment, Kirsty is just going to tell you a bit about the IVIC project and what exactly we're looking at, and then there'll be an opportunity for questions. There's some further reading. I think my slide has gone again. So if you're interested in this area, there's a lot of literature out there. David Ormrod did a piece in Expert Evidence and Scientific Proof in Criminal Trials, and he's also done some papers in the Criminal Law Review that review the law in this area. Daniel Yami, who's a Canadian psychologist, wrote a very good paper in 1995. It's very user-friendly for non-psychologists, reviewing all the different issues that arise with speaker identification in relation to memory and encoding voices. And then there are a couple of papers that I've written in the Criminal Law Review, one of them looking at voice parades and one of them looking at juror comparison exercises. If you'd like a copy of one of those, feel free to drop me a line and I'd be happy to send one over to you. So thank you for your time this evening. Excuse me, I'll hand back to Joe now.
Thanks, Jeremy. That's fascinating. So we've heard from Kirsty what the tools are in the phonetician's toolkit. What's the science? What things ought to be happening when we're trying to do voice identification? And you've heard from Jeremy how the genuine but sometimes ill-informed attempts to bring voice evidence to courts have been received by courts. Sometimes, I have to say, by courts who themselves were rather ill-informed. And you've heard a little bit about the way that voice identification, examples of voice identification processes have been used in the courts, have been abused in the courts, perhaps, and also sometimes rejected. So bringing those two different approaches together, how do those two worlds come together? Well, the answer is in the Improving Voice Identification Procedures project. And as you're going to hear, one of the most obvious strands of that is going to be to look at ideal parameters for voice parades and setting out some certainties that will help those who are trying to deal with voice identification to produce material which can be put confidently before a court. But it wouldn't be a multidisciplinary project if that's all it was doing. And as well as doing the obvious, which is that, it's also doing some other really important things as well. One of them is to attack some of the myths that lawyers may have and the general public might have about voice identification. It's also, in terms of enrichment, looking at some other really interesting areas as well, including social stereotyping, and also, again, just looking very closely at what the phonetics tells us, what the science tells us about distinctiveness of voices as well. So all of those things are being brought together, and Kirsty is going to come back and take us through how these two different worlds are being resolved together. Thank you, Kirsty.
Thanks very much, Joe. And you've actually given a very nice introduction to the IVIP project in your little introduction there. But here's a bit more about the IVIP project. My slides. There we go. So the acronym IVIP stands for Improving Voice Identification Procedures, as Joe and Jeremy have highlighted. And this is a research project which is sponsored by the Economic and Social Research Council. We're very grateful to have the opportunity to bring together researchers from a very wide range of disciplines, which are all relevant and important in tackling issues behind improving voice identification procedures, specifically in the ear witness context for this project. So you can see a photo of the team members on the slide there. That was taken about 2 weeks before the March lockdown. The project brings together researchers from Cambridge, Nottingham Trent University, De Montfort and Oxford. You can see all our names on the slide there, and all the different disciplines. So it's phonetics, psychology, sociolinguistics, law and criminology as well. So from the talk that I did and from some of the material that Jeremy's presented as well, we gave the outline for how voice parade construction is expected to take place in England and Wales, but there are obviously a number of practical issues that come with this. Preparing a voice parade is very time consuming. It takes labour-intensive work and it's expensive as well. Each case requires its own bespoke parade to be created to suit the voice of the individual suspect in that case. We don't have a speedy, efficient way of putting the parades together the way they do for the visual parades with the Viper video identity parades that are used today. For voice parades, it's very much an individual, one at a time approach. Finding enough recordings of voices that are appropriate to use for foil voices for parade can be very difficult. The phonetician sometimes has to go back to the police and ask for more recordings, and this is all taking time and costing more money as well. This is both in terms of finding enough speakers in the first place to get your 8 foils together and the amount of material available for each of those 8 foil speakers. Jeremy mentioned briefly the Freedom of Information investigation that he carried out and published in 2017. I just wanted to speak a little bit more about that investigation. He looked at the use of voice parades in England and Wales for the 10-year period between 2005 and 2015 and approached all 43 police forces with all of them responding except for 2. And this pie chart shows in more detail the responses that he received from those police forces. So if we start with the purple section, we had 10% of forces indicated that they had used the voice parade procedure. In red, we've got 10% that indicated they'd considered or would consider using the procedure. By contrast, in the green section, 51% had not conducted any parades or didn't hold data to suggest a voice parade had taken place. In yellow, there were 12% of police forces that did not retain retrievable data on voice parades. And then finally, in the blue section, there were 17% of police forces who had a policy decision not to construct voice parades. So within the IVIC project, we'd really like to tackle how we can improve knowledge and consistency of practice in voice parade usage across England and Wales, and look at how are there ways that we can make the procedure more effective and efficient as well. So the 4 strands of the different areas of research that we're undertaking in IVIP, as Joe mentioned briefly already, I'm showing now their sort of titles and objectives on this screen here. The parameters strand is the first strand, and it aims to establish optimal parameter values for voice parade procedures. So I said in my first talk that the Home Office guidelines for voice parades were developed as an extension of the visual identity parade method, but there's been lots of psychology research since then highlighting the differences between individuals, highlighting the differences between human responses to voices and faces and the way we process them. They're not identical processes in terms of the psychology. So it's not really appropriate to just apply an eyewitness procedure to an ear witness situation. We need a lot more research about how ear witness performance actually works. So the voice parade procedure could perhaps be adjusted to improve accuracy and efficiency by adjusting some of the parameters in the parade procedure. For example, the 60-second sample length for the voices has not, until our project got underway, been tested. Could we manage with shorter voice samples, for example, and get just as effective response rates, or perhaps even improve response rates? This would make the construction process for the parades much quicker as well as perhaps improving accuracy. Also looking at things like the number of foil voices, the instructions to the witness, and the type of parade. These kinds of things are what we're doing experiments on in the parameters strand in an attempt to identify optimal parameters to increase both the chances that guilty suspects are selected and innocent suspects are not selected when a voice parade procedure is conducted. In the second strand, the voice distinctiveness strand, we're looking at exploring the psychophonetic underpinnings of voice distinctiveness. So this is the very phonetic part of the project, really. In voice parade experiments, we tend to find that certain target speakers are more readily identifiable than other speakers, and we want to know more about what makes some speakers more distinctive sounding than others, and also whether those more distinctive sounding speakers are easier to remember. So in this part of the project, we're conducting experiments to look at whether the distinctiveness of a voice depends on how usual or unusual the voice is with respect to particular phonetic features known to be perceptually important for speaker identity. In the social stereotypes strand, we have the aim of investigating how social stereotypes affect voice identification. So looking at the extent to which social perceptions, judgments, attitudes and stereotypes related to voices can motivate the decision-making that witnesses undertake when doing a voice parade. So we aim here to assess the influence of listener attitudes on the parade outcome and hopefully improve the quality of evidence produced. And one aspect in particular we're looking at in this strand is the impact of different regional accents of British English on listener judgments about voices and associated stereotypes. And then finally, we've got the legal interaction strand, and this has the aim of examining the accuracy of criminal justice practitioners' knowledge and beliefs with respect to voice identification procedures. In this part of the project, we're aiming to develop a picture of experience of and assumptions about ear witness evidence of agents within the criminal justice system, so particularly lawyers and police officers. And looking at the extent to which these assumptions about the effectiveness and validity of voice parades impact on the use of ear witness evidence for cases. As you might have guessed, the work that you did in answering the survey today will contribute to our work in the legal interaction strand. So that brings me to the final slide then, which is our information about the project as available on our website. Very much encourage you to keep in touch with the project through visiting the website or looking at our Twitter feed, and please do get in touch by email. Contact Jeremy or me with the email addresses there if you've got any questions or ideas or things that you think we should be thinking about in relation to voice identification. Thank you very much.
Thank you both very much indeed. And we've had an opportunity just to have some questions coming up in the chat. And now is an opportunity perhaps for you to be thinking about any questions that you've got for our speakers. While you're doing that, can I just thank Kirsty and Jeremy for their presentations, and Kirsty for the opportunity to do a live test. I don't know whether there's any such thing as a super recognizer when it comes to voice identifications as perhaps there might be for visual, and I'm sure some of the research that you're looking at will help to be able to test the ability of individuals to be able to recall and to identify voices. I'm proposing myself as a potential super recognizer because I got Sunderland and I also got number 4.
Ah, excellent.
I think they might have just been lucky guesses, but there are an awful lot of places in the northeast. So have you got any thoughts on those things?
Oh, wow. Okay. So I haven't myself done research on super recognizers, and in the ear witness area, I think that's an area waiting to be investigated, really. Now I'm being put on the spot. It's Josh, I think it's Davis is the big name for super recognition in the eyewitness area. And I think he may have done a little bit on ear witness as well, which I really need to look into. Our colleague, Harriet Smith, works with him. And have you done something with him as well, Jeremy?
I think, well, yes, I've done a paper with him. I think that's something he's starting to look at the moment. I think that's something him and Harriet are in the process of looking at. But yeah, that's potentially a very interesting question, because how you establish whether someone's a super recognizer may be central to the admissibility of ear witness evidence in a case, and whether you'd be able to call that as evidence or whether that would just be witness supporting, I don't know, but it's something that would be useful to understand, but not just from a legal point of view, I think from a much wider perspective.
Excellent. Scope for IVIP 2 then.
Yes.
You just have to complete IVIP 1 though. Okay, lovely, thank you. I see there's a question from Keith Gordon, who's one of the people online, and he says it seems to be the case that the development of technology and police methodologies is completely out of sync with the development of the law. Well, that's the first point which has come out, I think, loud and clear from Jeremy's presentation. And the question is whether that mismatch is unique to voice identification. I was just thinking about that. I had a moment to think about that in advance. Whenever we have new technologies for identification, there is the starting point is the instinctive feel that there must be some use for this material. Whether it was fingerprints, surely there must be a use for fingerprints, and then later, much later. Other technologies like, for example, ear prints, actually the print of an ear, whether that is distinctive. Another area quite recently has been gait analysis, and that's the analysis of the way people walk. And with all of these, you have the instinctive feel that there might be something that can be said about a person, or a person's behavior, or an attribute of a person that may be relevant to their identification. And getting that instinctive feel into a scientific set of parameters so that the material can be presented and analysed and considered in the right way is plainly very important. And so there may be some very informal processes which are produced at the outset. And over time, it's the interaction between the science and the law that focuses everybody on what is not just good science, but also good and proper and safe evidence for the court. I don't know, Jeremy, if you've got some other examples which...
well, yes, I mean, that's... I mean,
I
was thinking earprints was the first thing that came to mind, because that was something that was tested, but ultimately led to a wrongful conviction. And often when, in fact, going back to Rob, which I mentioned earlier, that in this jurisdiction, we have an approach which, if you can establish that there is sufficient expertise in a subject and that this is worthy of scientific consideration, that evidence is potentially admissible. And we live in a time when obviously new technologies are being developed and new ways of looking at things are being developed, and there comes a point at which that goes from being the theoretical and to the practical. But the law will, and often the legal ramifications might be being explored for the first time during the trial process, and so it's often the case that that things are tried, and sometimes they the holes in identified at the time, and sometimes, unfortunately, the holes in them are not identified until sometime down the line, sometimes when overturning a conviction. So that's one of the big challenges the law faces with new technologies, and especially where you've got something that is primarily mechanically or electronically generated. Understanding the basis by which that comparison, that decision has been made, is something that lawyers and courts have to struggle to grapple with.
Yes, I think when we're dealing with evidence which may point towards the identification of a particular person, we're dealing with a wide range of material. Some material that may be descriptive, like the person had a beard. Some that might be distinctive, like the person had a beard which was turned into a plait. And some that might be definitive. And there's no database of people with beards with plaits. And so we're looking, I think, in this project at approaching the definitive, so not merely descriptive of roughly what somebody sounds like, but approaching a way of being able to get evidence to the jury for them to consider whether something is not only distinctive but very, very strong evidence of an identification between the voice and the individual. And it's getting that, the law is always quite open to circumstantial evidence which just points in one direction rather than another. It's actually getting it from that very rough level, which may be admissible but carry quite little weight, and getting it to something that may, in certain circumstances, carry very, very great weight. And that's the responsibility that everybody takes on, and that's why getting the procedures right, making sure juries are directed properly and that they're pointed towards the weaknesses as well as the strengths of any of that type of evidence. That's why it's such an important thing, because justice is all about doing justice. That means convicting guilty people, but also making absolutely sure that nobody who's not guilty ever gets close. Yes, have we got more questions? I'm not sure that we have. Now's the chance, though, for those who are beaming in from all around the world.
Okay, so there is a question that Jeremy's put to me, which I'm trying to work out. Can you ask it, Jeremy?
Yeah, what might be helpful, Kirsty, if any preliminary findings that you
right, that one. So Yes, in the parameters strand, the one that Jeremy is interested in, I think the first of the 4 strands where we're looking at these different experiments, I sort of mentioned about looking at the sample duration, the 60 seconds. We have done an experiment on that, and we're just sort of publishing at the moment. We have got a preprint that we've put, so I left it as though the results were still to be determined. But what we have found is that in comparing sample lengths of 60 seconds, 30 seconds and 15 seconds for the set of circumstances of the experiment we devised, we didn't get a significant difference in identification rates between those 3 different sample lengths. The rates of identification were similar across the 3 different sample lengths. So it seems that according to the statistical analysis, it would actually be okay to reduce the duration of those samples to less than 60 seconds, which would make the parade shorter and less work for the phonetician to put together, and open up the possibility of using more, when you're looking for the police interview recordings in the first place, more will be available because you don't need as much material for them. So that is the finding that that we do argue in this paper. But of course it was an experiment with specific conditions. So the participants were exposed to the voice, then they had to do a distractor task, and then they did the parade not that much longer afterwards, in the say, a bit like in the lecture today. So there's always this kind of balance between what you can do in an experiment and the actual real world context of doing a voice parade, and how much you can infer from the experiment to the real world situation. But on the basis of our findings, we're fairly confident that we could do parades with shorter samples. So that is what we're going to recommend if our article is accepted and published. Yeah, so that's one finding from the project so far anyway. We also did another experiment interconnected with that experiment, looking at the number of foils in the parade, whether that could be reduced or not. And we compared, 6 voice parades compared with 9 voice parades. And in that situation, we decided that we should really stick with the 9 voices because of the additional statistical protection for the suspect. It caught me on the spot, so I don't want to say exactly how the numbers worked out, but that was our conclusion, that we shouldn't reduce the total number of speakers in the parade unless there's some different evidence from future studies. But we still want to go with the 9 for now. So that's a couple of early findings from the experimental work we've been doing.
Thanks very much. That really demonstrates the care that you're going into in order to approach this idea of definitive evidence, or evidence which is in expert terms very strong. And that's in the criminal context, where the burden of proof is on the Crown and the standard is a high one in the sense of jury have to be sure. And so you're always working up against the standard of proof being, if not at 100%, at 99.5%. So that's what's necessary to make a jury sure. And that's a very good discipline to work to. But I just wonder, are there crossovers for voice identification in civil cases where the scope for admissibility is much wider and the standard of proof is much lower? So it's a balance of probabilities, whether something is more likely than not. Are there crossovers there? I have to admit, I haven't actually done any civil case work myself, and I would need to consult with other forensic phonetician colleagues about what kinds of situations have come up. And I don't know whether ear witness evidence has actually been used in a civil type situation at all. It's probably more the cases where there are recordings, is my guess. But I'd want to talk to one of the more frequently casework conducting colleagues. There are a number of consultants who do forensic
casework full time, whereas I just do occasional cases. So I haven't done a civil case. I'm not.
I don't know, Jeremy, if you've got experience of working in civil cases or thinking.
I've never.
Civil.
In fact, well, actually, I can sort of, not from casework, but my personal experience, where I was involved in a car accident with someone who later denied that they'd been involved in the accident, and it all turned upon the accuracy of my description of her voice.
Really?
So was it the accuracy of your recording as you
yeah, well,
running out?
And also the fact she'd given me her business card. But so it does come up. But I know that I've heard from corpus linguistics people that they've been involved in cases where, for example, of industrial espionage, where there have been emails sent and they've used their ability to analyze written text. So I suspect that's where its application is going to be identifying types of commercial blackmail or those sort of situations. So I suspect probably the quasi-criminal side of civil would be my guess as to where it's going to come up most frequently, or indeed, cases involving. I seem to recall something, and I need to look it up, but a defamation case where there was an issue about who was broadcasting something.
And
so I think it's
leaving voicemails, that sort of thing.
Yeah.
Okay, I see a fascinating question, and this is putting you on the spot on the Ripper hoax. So we're going back to Sunderland now,
right?
And just testing your knowledge of that case. You said that the expert said that he thought it was a hoax. And so wherever it was, don't send people around to Sunderland, because that's not going to get you to the person that you want. And was there anything in the voice or the language or the content?
Yes, I'd need to go back to it. If anyone is really interested in that case, there are various reports about it in the Forensic Linguistics Journal, International Journal of Speech, Language and the Law. But as well, you can find on YouTube a documentary that goes for about an hour, I think, about the Yorkshire Ripper hoax, specifically about the linguistic analysis that went into it, with interviews with Stanley Ellis, the phonetician who was involved, and also there was Jack Windsor-Lewis was another linguistic expert who contributed, and both of them said they thought it was a hoax. I can't remember their exact intuition about why, but if you want to watch that documentary on YouTube, it's gone into a lot of detail. So they went around Sunderland and other related areas listening to local speakers and trying to get us, and I think they got a sense of not only the subtle differences in the dialect around that region, but some of the sort of community dynamics as well, and that might have contributed to this hunch. Sorry, I haven't brushed up on all the details for today.
Very well, thank you. We've had just a comment from an audience member who says it's been a fascinating insight into an area of linguistics that I was previously unaware of. Just starting my journey in learning about this field of science as a first-year undergrad. Thank you. Well, you're very welcome.
Lovely.
And I'm pleased that you're aboard with us and you found it as interesting as I do and we do. That's fantastic. I want to bring these proceedings soon to a close, but again, just putting you on the spot, I just wonder, we talked about IVIC 2, and could you tell us something about the timescale for the voice identification project? And where you think you might be going when you get to the end?
So more and more ideas for more experiments keep coming up the more you study, but
cool.
we've got 2 more years on the current project with our research team, with the research assistant and postdoc who are part of our group. So it will be around about October 2023 when we sort of officially wind up the project. And in the last 6 months, we're planning on having a lot more of this kind of thing, sharing the findings with the relevant stakeholders. And now that we can do this webinar format, there's no reason not to make it easy for people all around the UK and internationally to sort of access our stuff. Jeremy and I haven't really discussed IVIP 2 yet, but I've got lots of ideas. I'm doing, actually not as part of IVIP, but using some IVIP data. One of my PhD students, Linda Gerlach, has been looking at automatic speaker recognition techniques in conjunction with perception of voices, and can we actually mirror this idea of listeners judging certain voices as being similar the way you would for choosing the foils in those fairness experiments. Can we actually get these machine techniques to help us with that, so that it would be a faster process for selecting foil voices? If the automatic speaker recognition software can speed up that part of the parade construction, then that would be really a very big leap in what we're able to achieve. And there are lots of other steps that would need to go into making the parades faster and more efficient, but I think this is really an exciting area that I would like to see IVIP 2 follow with further. Yeah.
That's great. We've got a number of practitioners at different stages of their career journeys, and a query from one participant saying, thanks so much for the presentation. Do you know of any opportunities for postgraduates to develop experience in the specialism? Well, I'm sure the answer is yes.
So you're very welcome to enrol in a master's or PhD in Cambridge and come and study with me if you'd like to. It would be unfair of me not to mention the master's course at the University of York, where they have a specialisation in forensic phonetics as well. So there's a number of academics in forensic phonetics at York, and you can do an MA in forensic phonetics and then see where that takes you. Those would be the first two places that I would suggest if you're interested in university study of this area. If you want to sort of do work experience, then I think you'd need to do an internet search and see who the forensic phonetic consultants are, and perhaps approach one of them and see what comes of that. Also, you could join IAFPA, or at least attend an IAFPA conference, the International Association of Forensic Phonetics and Acoustics. Make some contacts there, and see if that takes you further as well.
And just a point about COVID, have you been hampered by... There we are, well, that's the question.
Yes, who has not been hampered by COVID?
It's a time-limited project, and there's been a need to crack on with it.
Yes.
How have you coped?
Sure. Well, when I said we've got 2 years to go, that is because we have had an extension from the Economic and Social Research Council, and in fact being given some more money, partly from ESRC and also from a Newton Trust grant in Cambridge, so that we can extend for longer, because the way we had originally planned the experiments with participants physically coming into labs and putting on the headphones and listening in the same experimental setup just hasn't been possible since the world's turned upside down with COVID. But we've learnt all these new techniques of doing online experiments and made various adjustments. So we're forging on, and there were some unhappy moments in the earlier stages of COVID, but we've learned how to manage with that. And of course, I mean, we're in 4 universities now. We can meet once a month and have these Zoom meetings the way we hadn't really dreamt of when the project started. So that has actually been a big plus.
Well, that is one very significant thing that's emerged in the course of the last 18 months or so, which is the ability to be able to network and to Zoom, and to have people following this sort of project on Eventbrite, and being able to participate. I think there's a form going on in the chat for people to leave contact details, and you're very welcome to do that. Say what your interest is, remain in touch with us and come back and join us as the project continues and develops. I think we're just coming up to time and wanting to make sure that we finish on time and on budget. It only remains for me really to say the obvious, which is to thank Kirsty, thank Jeremy very much indeed. And they're at the head of a team which, as you've seen, is a team of great depth and great diversity. So thanks to all of you. And thanks to all the delegates, all the people who've been on this call with us. Thank you for your participation, and I hope you join us again very shortly when we have the next stage. Very well. Thanks very much indeed. I think that's us coming to an end.
Thank you.